Thank you. Guess you have to control everything.
Okay.
Okay, sign, join the webinar.
Hi, good morning, everybody. Christopher here. Hope everyone's having a good day.
Hi, Ivan, can you hear me? Okay. Go ahead with the presentation. Yeah. Yeah, I will let you know. Whoever has a question, I'll let you know. Yeah. Can everyone hear Ivan? Ivan, people cannot hear you. Okay, what about now, Ivan?
You talking now?
Your volume is
Very
very
low.
low.
How about speak closer to the phone? How about now? Can everybody hear me? Oh, goodness. Hello, everybody? How about now, Calvin? I'm just holding.
Still very low.
Calvin?
Yeah,
Can everybody hear me yet?
still low.
What's going on? Settings, privacy, settings. Okay, good. Try to find it. I'm trying to connect back. Can everybody hear me now?
Sorry guys, oops. Sorry guys, we're going through some technical difficulty with Ivan. He's never used Zoom before, so he's trying to find his speakers where he can talk into the microphone. So just bear with him for a second here. Ivan, you can talk now.
Oh, can everybody hear me now?
Better, yes.
Oh, good. Oh, sorry. My goodness. This is the first time. Sorry. Thanks for all your patience, everybody. Technical issues here. Hope everybody out there is safe, healthy, and try to keep you for this time. Anyways, a little bit about myself to begin with. So my name is I've been there for 22 years, at most stayed for the whole time. I do also litigation. I do corporate commercial. I do wills and estates as and it deals with today. This I presentation about a couple of months ago, but there's some aspects of times that are.
Ivan, are you using Wi-Fi or data?
So today.
Ivan, are you using your data or your Wi-Fi? Can you use your data?
Just turn it off.
Yeah, turn it off. Use your data.
Yeah. Turn it off. And okay, how about it's off now?
Yeah, so much better. Yeah, thank you.
Oh goodness. So data, no Wi-Fi. Unfortunately, Wi-Fi. Stay away from Wi-Fi if you're doing this. Anyways, so today's topic, we'll be talking about contract assignments. A lot of you have, actually, maybe this is the first poll question. I want to ask how many out there have dealt with assignments of sales contracts, either pre-sales or even with resales of houses. Maybe have a quick poll. I just want to get a sense of who out there in the audience right now have dealt with it, have thought about it, or maybe are thinking about having a potential deal with this issue. So if you can just to answer the question, have you had to deal with it? Have you had experience with contracts? So I have a sense of contract assignments. Have a quick question, have a poll, and that'll give me a sense of the audience so I can address you further. Now, in this, just before we go, because I'm talking through my phone, I don't have a sense of the audience. How many people are listening in, Calvin?
This morning we have about 27 attended, including you. Yeah.
Okay, that sounds good. How long does it take for this poll for everybody to do
we only have 14 people answering. Guys, can you guys just answer the questions?
Yeah, just a quick one, just so I have a sense of who have dealt with it and who haven't. Just give me a sense out of the 24 or 23. And then we can go on.
Ivan, I would say today's training about 50-50. Yeah.
Okay, 50-50. Okay, thank you so much. I just want to give you the beginning point. What is an assignment of contract? One of the more important things, this is the next screen, Calvin, is that assignment of a contract, there is not like an assignment of a property. What it is if you go to the third screen, Calvin, when the rights to a contract of purchase and sale of real estate are transferred to a third party, and the person who transferred these rights, to give them a name, is called the assignor, and the receiver is called an assignee. It's important to note that these are rights and the contractual rights that are being transferred. It's not the actual property, it's the rights that are contained in the original contract or in the contract assignment. So it's very important in this situation because you're not transferring an actual property, but it's the rights that are associated to define what are those rights. What are those rights? So if you go to the next screen, page 4, this is the question: what are the minimum requirements of an assignment? So any kind of an assignment where you're transferring rights of a contract to a purchase, what should it include? Now you go to screen 5. There's some basics. You just have to have all of these items, and and I've incorporated some of the new terms that are in the standard assignment, a standard contract of purchase and sales. So the first one, you have to make sure that the assignor, the person giving these rights, which is usually the buyer, who has an existing contract with the seller, has the right to assign it, and that the assignee, the person receiving it, has the right to receive it. These are just general questions. So when you have parties and you have a client who's a buyer and you have maybe a client who wants to buy an assignment, you want to make sure that these individuals have the authority to sign and to purchase and also to sell. Number 2, the proper assignment agreement is drafted and executed. You do not want to miss anything out in an agreement, and you want to make sure it's properly and well done. A lot of the terms are in the, especially when it comes to pre-sales, the many of the terms are required of what needs to be filled in are in the standard assignment for pre-sales and developer pre-sales contracts. There's a lot of blanks to fill in so that you can't miss it because all the questions are asked. How you fill it in is a different matter, but at least you have it all filled, okay? Number 3, is the assignor aware of its obligations to provide notice to the assignment of the assignment to the owner, unless the assignment option clauses are used? Now, we'll talk about this more and further, but it has to deal with the obligations to inform the owner of the land who's selling of if there's an assignment and what are the terms of the assignment. Number 4, the identities of the parties are clear and verified. Now, verified isn't just the FinTrack information. It's actually the couple of things, such as, are they buying on behalf of someone? Are they married? Are they non-residents? Are they residents of Canada or not? Or the citizens? So these are all information you need to know before going into a contract assignment. And then number 6, as I mentioned earlier, we're talking about rights. An assignment is about rights and how you define those rights based on the contracts and whatever you put down into an agreement. One of the most important things to deal with is all the things that could be involved in terms of money. The bare minimum sometimes when it comes to these contracts is an initial deposit. The buyer or the assignor would have given some monies as a deposit to have the contractual rights to buy. But how is that dealt with? When is it going to be released? Who is it going to be given to? Secondly, GST, especially when it comes to brand new properties, pre-sales, but even not only condos and townhouses, but even brand new homes, where there's a contract to buy a house that's being constructed. So it's not just stratas, okay? So who is to pay the GST? How is it to be paid? And even if GST is applicable. That's important. These are just 2 points out of all the different the financial considerations to make. And number 6, I just briefly alluded to it, but residency issues. In the last couple of years, there's a lot of these issues that have come up with an assignor who happens to be a non-resident, and what to do about it and how to deal with those types of issues. And we'll talk about that at the very end, the latter part of this presentation. Okay, so we got these basics, and also one of the things is anybody who wants a copy of this PDF or the PowerPoint, it's saved as a PDF. We can email to us or say, "Can I give a copy?" And we'll email that out to you. Now we go to the next screen. So in terms of what is required in all standard real estate contracts now, there's a term that's required since of May of 2016. And these are 2 standard, and we can just call them default assignment clauses that are in every contract. And then what those 2 are: 1, the contract is not to be signed without the written consent of the seller. You have to have written consent. And second, seller is entitled to any profit resulting from the assignment of the contract by the buyer or the subsequent assignee. Now, when I talk about the first part a little bit, written consent of the seller. So how do you get that? You have to have that in writing. It's written consent, not the verbal. And it's probably safer protocol in most sense to have something written. So safer for anything, and dated and written, and if possible, even witnessed. Number 2, seller is entitled to any profit, and they don't define profit in this regulation. So that comes to, in some other contexts, a lot of issues dealing with how to define profit. Is it the assignment amount minus the commission? Is it minus expenses? How do you define it? It's not defined. So in any other contract, you might need to define exactly what that is. And then number 2, it says the assignment of the contract by the buyer or subsequent assignee. So any profit anywhere down the line. So if a buyer turns around and assigns it, and the end person who received that assignment in turn assigns it again, all of the profit has to be going to the seller. So now in situations where you see these 2 standard clauses and you don't, you want to add terms, you want to change it. The buyer doesn't agree. The assignor, assignee wants to change something. Anytime that you need to amend any of these 2 terms, you have to give notice to the seller. But when you give notice to the seller, you have to give it in the proper form. Now, if you move to the next screen,
Ivan, there's a question. Someone
yeah.
asked, is this for a pre-sale contract?
Pre-sale contracts is when there is an assignment for a pre-sale, they have a specific one for that. It does change, but they're different terms, and I'll get to that later on when I talk about pre-sales. there are specific things. Developers are quite often, or they're exempt from these their contracts. Anyways, they have a specific contract.
So the question is, this is an assignment for resale purchase. Is that correct?
Yeah, that's correct. Yeah. For developers, they have a very specific form and they have different rules. But for resales, this is important. Now, if you go to exactly how, and basically to summarize, if either one of these two terms, these default clauses are changed, or they don't include either one of these two, then you have to give a notice to the seller regarding the assignment. And there's a standard form for it. It's at page 9 of the PDF. You've seen these. You need to do this if you change any of those two standard terms for resales. I want to talk a little bit about this notice to the seller. You'll notice that in the Part A, you need to have the, actually, if you look at a little bit further on Part signatures and acknowledgement, those are very important. And the Part A also has the date the notice was provided. When the Part B is signed by the seller, this is your proof and evidence and confirmation that the seller has been given written notification. So don't skip this part. You know, the seller you may send it to the seller and they forget to sign or what, but this is very important to have, because this protects you as the you know, you're the licensee who's offering this offer to the seller. And anything that changes any of those two standard terms, you want to make sure you cover yourself that the seller has been notified, okay? And this is regardless of if you're adding a word or adding a sentence or changing part of it or defining it further, you need to do this. Other than all profits and any profits, and the idea that any consent has to be written acknowledgement. So anytime you have a sense that something needs to be changed, this has to be done. And getting that Part B signed is very important. Now, your managing broker would say, you know, well, the last part is just as important, you know, for the brokerage to have you sign and to someone from the brokerage receive that notice, so that the brokerage itself is also made aware of it and has knowledge of it and records it. Your obligations is not just for yourself and your clients, but also to your brokerage to protect everybody, to make sure all the proper steps are done. Now, if you go to page 10, say, for example, you do have a situation where that you wish to do some changes and you want to make it, what do you need to do? Now, your managing brokers, they've had this PDF at page 11 of the PDF, Calvin, what to do and how to do it. So you have a potential buyer of an assignor that may want to, you know, your buyer wants to add the spouse, or they want to transfer to a company, or they want to add a husband to the contract instead of having everything purchased by the spouse. So anytime you want to change it, you need to strike out those two default clauses, and then add the terms that are indicated in number 11. Now, do you have page 11 on the screen, Calvin?
Yes.
Yeah, so you can get these exactly from your brokers. It's something that was sent to me by Christopher Hughes, and these have been sent and is made available to agents on how to draft your contract if there is a change that's needed. So you strike out the default clauses, the first part, and then you add this assignment option clause. So this is important. So the buyer reserves the right to assign this contract in whole or in part. A whole or in part is good. It's important because you might want to give, you know, give part of it to someone. Like if you even add a person's name, is 50% being transferred to any third party without further notice to the seller. So this allows you to make those changes without providing written notice. Set assignment, and this part is important too. Set assignment not to relieve the buyer from his or her obligation to complete the terms and conditions of this contract should the assignee default. So earlier I mentioned a little bit about what are the things that you need to have in an assignment contract. when you put these as an addendum, this deals with two, what situations can the buyer assign it, and how much of it then can they assign? Do they have to provide notice? And then the consequences if something down the line doesn't happen, such as if later on the new assignee doesn't complete. And so, and quite often, and this is very a common situation and it's unusual not to have this, is a complete release of the buyer if the assignee defaults. This doesn't happen often. You don't want to go there because as the assignor, you may want to, but as a person buying an assignment from someone else, it's very important because who is responsible if something doesn't happen later on, if the completion doesn't happen, and what the reason for that non-completion happens. So in this situation, the buyer still then will not be relieved if the assignee defaults. Okay, and then the notice that was just provided in page 10, the notice of assignment to the seller, that has to be combined and given to the seller along with these changes to the offer. Now the other part 2, which is at the bottom, additional buyer assignment clause. It says, notwithstanding section 28, the parties agree that the buyer may, without consent of the seller, and this is again part that, so you can waive the requirement of having written agreement and waiting for the seller to approve and waiting for their considerations. You can add the person's name, add the insert name of the specific party or parties as an additional buyer to the contract prior to closing. The seller's consent does not release the buyer from liability under the contract. So this is a situation if you know that maybe, and quite often lately in the last little while, that I have the parents going into the pre-sales planning on buying a condo or buying a house and thinking about transferring it to their kids, or husband going in thinking, oh, I'm going to add my wife on later on. In general, this is in general too as well. So you want to make sure that they can add anyone else to the party, or you can have an investor who's thinking, oh yeah, I'll put the contract name and maybe I'll have my company, my holding company, be the one that will eventually buy. So any of these situations, you might want to have this clause in, so that allows that option to happen, and give it to the seller along with the notice to seller regarding any changes to the standard assignment clauses. Page 12, I just highlighted some of the important terms of those standard of those changes that are suggested in the wordings. So page 12 of the PDF, I highlighted certain important words: assigned in whole or in part. Part of the contract allows part of it or a portion of the contract to be assigned. The words "without further notice to the seller" that relieves the obligation to ask and requests the seller to approve it. And then the other part, the buyer is not released from the terms of the contract, which deals with what happens if there's defaults down the line. There's all kinds of reasons. So when in more specific contracts, they should indicate when it comes to liability, how it's proven. It's important to write down if they're the person who's defaulting, and then what are the consequences of that. So you have the assignee default or something that the assignor did that causes the non-completion to happen. At least those should be specified. Page 13, what are some sample situations in which you wish to strike that out and amend the default clauses and give that notice? And we just mentioned some of them already. And page 14, if you want, the rights are given to another family member, or an investor wants to use a company instead. And sometimes as well, when it comes to profit, how to divide the profit. So sometimes you might want to make some changes because if, for example, there's a division of the lift that may be needed, and then the buyer gets some of it and the seller gets some of it, not all of it, or if there is any kind of fees to be paid. Okay. Now, if you go to page 15, now you asked the question
Ivan,
earlier.
sorry, Ivan, there's a question here
Yeah, go ahead.
for the second clause. Does it mean you can only add not to transfer? That means the buyer still have to be on the contract?
No, it means the buyer doesn't have to be always on. It could be someone else. You could the first part is all or none of the contract. If all of the contract is given, that means the seller is gone and all of it is transferred to someone else. Number B is like in terms of adding somebody, that means a person is still on. So you remove someone at the assignment option clause 1 completely, all of it is gone, the complete contract. If you're adding somebody, and that's number 2, is that you need 2 of them in order to deal with all these situations. Okay.
Is that answering your question, Tiffany?
Yeah. So Tiffany, an additional buyer, but if you're removing it, then number 1 is the one that's needed. So like item 1, you're assigning it in whole or in part. So if you assign the whole entire contract, that's like the buyer is being removed completely from being the one purchasing. Does that make sense? Okay. I'm not sure if Tiffany replied. That's right. I can't see the replies. It's good. Anyways, if it's okay, that I'll just continue. We go to the earlier question regarding pre-sales versus resales. Now, the pre-sales is a lot more, it's a different thing. The developers have very specific rules when it comes to allowing contracts that buyers have made with the developer to be reassigned and assigned to someone else. Page 16 of the PDF, I have a summary of some of the things that are different. Different rules for pre-sales and developer sellers. Developers never allow, very rarely, and I've never seen anyone yet, where the developer hasn't required consent. And is any developer, I've never seen anyone yet that would agree to have those other 2 clauses being put into any agreement. Developer's consent is therefore, don't even think about it, it's mandatory. The developer would not want to relinquish control over anybody who is transferring properties and contracts to anyone else. And usually, think about this too, assignment restrictions are usually exist based on the timing. So usually the developers would put a restriction on any potential of any assignment at all prior to completion. But at least at the very minimum, they have to wait until all their units are sold so that they're not competing in the market with people selling assignments versus people who haven't purchased or assigned contracts for existing units at a development that hasn't been sold yet. They don't want to compete with the assignment market. So the first part about the stage of development. Now, quite often you have to, and this is very important whenever you deal with any developer, you have to see exactly what the restrictions are. And in terms of the timing, okay? And then, and secondly, another part is the third part there, assignment fees. There is almost inevitable a fee, and that fee, you have to read it because when you are representing a potential buyer of an assignment, you have to know exactly what those fees are. And if you're marketing an assignment, you have to know what those fees are as well. Usually it is a percentage, and there's ranges anywhere from 1 to even 5%, which is quite standard in terms of the purchase price. So if you want to assign it, there's going to be a fee, and inevitably, the person who has the contract with the developer is the assignor. And if you want to change any of that, then you might need to specify it, but the assignor usually has to pay. And you want to make sure that in any, and it's specified in any contract who's going to be paying this and when. Quite often, when these contracts, the developer wants the payment at the time in which you apply to have an assignment being approved by the developer. Now, the developer will look into every situation and make a decision on whether or not they approve the person who's being assigned. But they'll charge that fee regardless, whether you're going to get it or not, you're going to have an application fee so that they can consider whether or not to approve it or not. Be aware of that. And so that's the last four. So any kind of a agreement, you have to make sure who's going to be paying this. Now there's something about these pre-sales which I want to talk further about, which is the assignment amount. This is the question on page 17 of the PDF. How to deal with the release of the assignment amount. Now, the lexicon it uses lift and also the deposit. I mentioned at the very beginning, one of the basics of any assignment agreement is how to deal with the deposits. Well, now when selling an assignment, usually there's a price to pay by the person who's buying the assignment. And what they pay is on top of any deposit that the seller, the assignor has already given. So when you think about the price for an assignment, it's usually the deposit plus the lift. Okay, so what are the basic questions that you need to have answered when dealing with what to deal with the assignment amount? And so you go to page 18. Now, who's going to hold it? These are basic questions that needs to be dealt with. What conditions are there on it? Now, conditions, you're used to these words, subject removal conditions. Assignee may need financing in order to purchase, and they need to, before an assignment becomes binding, they need to get financing. But one of the most important ones is, the developer's consent. Because the developer has to approve this, and if it's not approved, then what happens? And then the third question is, when is the assigned amount to be released? And later on I'll show you the standard clauses that are in the pre-sale assignment contracts. But this is very important. There's different options about when it's to be released. And fourth, what happens when an assignment does complete, and also what happens when it doesn't complete, like when the actual what conditions what needs to be addressed is what happens if the completion does not complete down the line. Okay.
I mean, there's a question.
Yeah. Go ahead.
From Min. Can the developer ask for a different fee that's different from what is specific in the original purchase contract?
Run that by me again. I couldn't quite hear. One more time.
Can the developer ask for a different fee that's different from what is specific in the original purchase contract?
If they were to do that, the question, if I ever heard that, is it should be inside a disclosure statement. So any changes into these fees may be buried inside a disclosure statement somewhere, someplace. So if you want to find that right, it could be somewhere in one of those disclosure statements that was received by the buyer. So if you want to find it, it should be in there.
So Ivan.
Yeah. Hi there, who's this?
Yeah, it's John. John Ng.
Oh, hi, John. Yeah.
Hey. So I think Min's question is, so let's say on the original contract, there is an assignment fee,
Yeah.
right? Yeah. And then can the developer change it later on in the disclosure statement? Do they have the right to do that?
Yeah, so it's not like if first of all, if they put any of these changes in the disclosure statement, and the buyer accepts it and reviews it, when they accept it, they have a few days to say, hey, I don't. Is it a material change or not? Should I buy it? Should I back out of it? Now, usually these fees, it's kind of. If it's like another percent, within the standard range that's happening around 1 to 5%, if they all of a sudden said, oh, we're going to change it from 1% to 50% or 60%, which is, crazy. I think these are grounds upon which someone could say, hey, this is, but mind you, this is a potential fee. Not everybody is going to be assigning. Does that make sense? So all the buyers who are contemplating and buying a developer, if buying from a developer, if the whole intention at the beginning was to flip this, this may be a big deal. But for most buyers, this is probably not something. Well, depending on the price, and depending on how much has changed, something that could be drastic.
Right.
Yeah.
So if they ask for, let's say in the originally they ask for 2% assignment fee, and then the problem is, once the buyer removed the subjects, and then the disclosures come along afterwards. So at that point, what can the buyer do? I mean, if they
Yeah.
say 2% to 4%.
I think within the range in which it's common, like 2 to 4, is that a big deal? To some people it is, but to some people it's not. So this would have to be on a case-by-case situation. It can't be a general statement saying, "Oh, you can back out of it. You can't back out." But when you get in the disclosure statement amendment that does this change, and really you have to look at it on a case-by-case basis. I don't think that in general, like a 2 to 4%, anywhere from 1 to 5 within that range is not gonna be enough in terms of an objective reason to say that nobody else would think that it's such a fundamental breach or change. Because who is it going to affect? That only will be affecting that percentage of buyers who eventually want to sell their contract.
Mm-hmm.
It's not affecting everybody.
Right.
It's just like you're changing. I suppose let's give an example of another thing that could happen with the disclosure statement. They change the location of the kitchen, or the patio gets moved from west to east or something like that. Does may affect aesthetics, but it doesn't affect what you're actually getting as X number of square footage of a property on a certain level. It's not enough to say, hey, this is such a big breach that I'm gonna back out of this deal, right?
Mm-hmm.
Yeah.
So can the developer ask for the increase of this fee when the assigner is asking permission to assign the contract?
No, they can't change
right?
it during that time. Yeah, because it's
You
not a
can't change it just like
contractual
that.
right.
It has to be in the disclosure statement.
Exactly.
Got it.
So,
Okay.
so be careful about reading it. Maybe and it could be buried in the language. I haven't exactly seen a clause that does this, that allows the developer to amend any time. Like the way they do was changes of when the completion date happened. They've got quite good language to allow them to keep on extending extending the completion. But I have not seen any clauses that allows them to keep on amending their price for the sum at any time they want.
Okay.
Yeah.
That
would be crazy. It's like,
it is.
that would be really something to fight about if that happens.
To fight about, yeah.
Yeah.
Okay.
Yeah. Yeah. What's the most? Just getting a poll out there, but for those who have dealt with developers, what is the highest amount of an assignment fee that you guys have come across? I wonder if someone could.
Let's ask the agents to put an answer. Oh, someone said 15%. Oh my God.
15. Wow. Should we name developers, guys? That is helping us, all of us, because if you have come across it, and then some agents may not have dealt with that developer before, at least you're helping your fellow agents out by sharing this information. So, it doesn't hurt. Well, who, if you don't mind, whoever mentioned 15, which developer charged that much?
Yeah, one said 5. Okay, 15% is Saxon in Burnaby.
Gee, okay.
SAXON.
Yeah.
One developer did ask for 25% from the lift. Wow.
Okay. Yeah, that's the different one too. Yeah, they're not even talking about the price. They're talking about the lift. That's less of the deposit. So, yeah.
That's not common though, right? Ask for the lift.
No, it's not common, but it also limits. But that's quite often the lift isn't that crazy either. So, I haven't seen crazy lifts that are like in hundreds and thousands either. So, if it's 25% of a lift of 100,000 lift, it's 25. It is still considerable, but the lift is smaller, then you get smaller. So yeah,
right.
Yeah, interesting. The one that did the 25% from the lift, which developer is that?
He said Saxon in Burnaby. So
As well.
Tim, what is the developer for Saxon? Let's see. Oh, it's a small developer.
Oh, wow. Okay. And the one that did the, sorry, I heard 15%. That's from the developer for the section. What about the 25% of the lift, that price? Which developer did?
25% of the lift. Matthew, which developer is that? Oh, One Burrard Place,
One Brevard Place. Okay.
downtown.
Oh, interesting. Yeah. Yeah. Actually, I guess gone are the one and 5 and 15 and 25. Wow, that's interesting. Well, yeah. So there's depending on what the
Yeah, there's a
developer
5% in the rise. 5%. Yeah.
they rise. That's good. Yeah, and I think it's a good indication for anyone who or any agents there who may have a potential buyer or looking for an assignment to consider that an overall cost when it comes to representing. Of course, can the developers charge that much? So if the market can support it and buyers are willing to pay for it, assignee market is willing for it.
So, just a question. So, the assignment fee usually the seller has to pay it, right?
Yeah, that's the normal.
Yeah.
Yeah.
So what if the seller actually they only have the money when the buyer pays them? They don't have the extra money to pay the assignment fee. So what's the steps? Do we get the money from the buyer first to pay the assignment fee, or?
Yeah, if the signer really wants to sell and the assignee really wants to buy, that's when you want to draft up an agreement or clause that protects especially the assignee, because you haven't even have the developer approve it yet. And once it's approved, and then what happens with the money? So question, say for example, if the assignee pays the developer fee, then you want to make sure that there's a way to deduct that amount from the assignment amount that's going to go to the assignor. You deduct it, right? So you pay $5,000 for the assignment on behalf of the assignor who's supposed to pay. Then you reduce the amount of the assignment amount that has to be paid upon subject removal. If there's a deposit that was given for $10,000 and $70,000 extra for the assignment amount to match it, then you take that 70, you minus what was given already to the assignor. I wouldn't advise that either, just because when you're adding an extra level of complications if the assigner isn't willing to pay upfront, to pay for it, and you want to have payment by bank draft or certified check, which is what the developers want. It's money, it's not a check. You want to make sure, because this money that's gone. It's as soon as you put that bank draft in the developer's name or the lawyers, it's gone. So the assignor, especially if he owes you money but doesn't later on disappears or something. So anyways, you do have to have a good agreement, and I would advise that that when the final amount, when subject is removed, when the developer gives their consent, that the rest or balance of the assignment amount that's supposed to be paid, it specifically minuses the assignor fee. Okay, I wouldn't advise it because it's just one level of complications. But if you just have to, make sure it's addressed that way. Right? Does that make sense? Sorry, who was the question from?
Yeah, I sort of got it.
Sorry, what's your name? I just hear a voice, but I don't.
Tiffany.
Oh, hi, Tiffany. Yeah, so the
Yes.
idea is that normally you don't want to, but if you do, you have to make sure it's some way of how to deal with that amount being fronted by the assignee. So in the contract itself, in the assignment amount, when it talks about how much is supposed to be paid to the assignor, you have to have it deducted. Yeah, so in a typical scenario, the assignee puts down a deposit. Say the assignment amount is $80,000, and the assignee would put down $10,000, hold it by the real estate agent, waiting for subjects to be removed, and then the application is made to the developer. Money is paid up front. So in the assignment amount, the amount that later on, when the subjects are removed, that should be deducting anything that the assignee has fronted for the assignor. You just find a way to deduct it later on, right? When subjects are removed, the balance of the assignment amount, like $70,000, is supposed to be paid, but you make sure that it's right in the contract that 70 less any money is given by the assignee to the developer for the assignment amount. And so the balance would then be, say 70, but the assignee had paid $5,000 on behalf of the assignor, so 65 would then be given. $10,000 is already as a deposit, another 65 reduce the assignment amount. The thing you have to be cautious about here is that the money is being reimbursed, but the assignment amount is still the same. Does that make sense? The assignment amount is important to know as a number because taxes are paid on it. GST normally is taxed on that assignment amount. So if it includes GST, well, you don't want to deduct the money that the assignee has already given, so that the assignment amount becomes a different. I'm just saying that money that the assignee gives has to be taken care of somehow. Does that make sense, Tiffany? I think sometimes if later on, maybe if you can send an email, what I can do, or something can be given to everybody is in a sample clause that deals with that situation. So in the event that the assignee provides the assignment of fee to the developer on behalf of the assignor agrees to reimburse the assignee upon subject removal. And even if the subject is not removed and the assignee has already paid it, you may want to put that in. But then you're looking at enforcement. You're looking at, say, developer says no, and the money's transferred and given to the developer for the consideration, right? So.
I think there's another question. The GST on the assignment amount, who pays for it?
So the question is about the GST. Now, in the standard form contract for pre-sale assignments, the GST is included in the assignment amount, and you have to, as an agent, and you're negotiating either that you have to know that it's included inside the assignment amount. So you take the assignment amount minus 5%. That is the net amount of the GST. And the reason why the standard contracts have that clause, the wording in, it says GST is included. It said nobody has to then haggle about it. It is a default. The assignor has to pay, and it's included, and the assignor has to remit it. The reason why that clause is in the standard agreement is because CRA, they look at the intention of the person who has to pay the GST to determine whether GST is payable or not. So in some situations, if the and the presumption is anybody who buys a pre-sale and signs a contract and doesn't complete on the deal eventually, what is their purpose? The presumption that the CRA would normally do is that this person wasn't planning to buy this place for themselves in the first place, meaning that they are speculating. They are not buying on purpose for themselves. They are trying to invest. They're not going to use it for themselves. They've always intended to not buy this property incomplete. In that situation, the GST CRA will say this is a person who is in their eyes a developer. A business person who's involved in buying and selling and marketing real estate contracts. And then therefore, when they sell something, GST is applicable. But how would the assignee know what the assignor's intention was all along? You're buying an assignment. If GST is left in doubt as to negotiate between the buyer and seller, the assignor and the assignee, how would the assignee ever know what the original or current intention for entering into the contract in the first place? it's difficult to know, to read someone's mind, even your spouse, for 25 years, you still can't read their minds. How do you know what the assignor's intention was? And so, hey, don't even bother making a burden on the assignee, the buyer of the assignment, to prove it. The assignor is responsible to pay. So then if there's any GST payable, well, the assignee doesn't have to deal with it. The assignor has to pay it. So one of the problems quite often when actually this leads on to the next couple of slides, is that there's certain if you ever want to go apart, let me go back again. There are 3 different types of options in the standard pre-sale contract assignment to deal with the assignment amount. And if you choose not to deal with any of those 3, and you choose like a different option, then you have to be really careful about what you say or don't say, and being clear about what is included or not. And that includes dealing with the GST. Now, with your question is, so the assignee doesn't have to pay, the assignor has to pay. The assignor has to remit it if it's payable. And that's why in the standard deal, in the standard contract, the assignee doesn't. The wording in there is that it's included, and it's important to know that. So now the person who's selling will say, hey, that means I get less amount in the profit. My lift is actually less than what it is. Well, if you are representing an assignor, yeah, you have an obligation to let them know that this is GST. Most likely 90%, 99% actually will be needed to be paid. The CRA they have a reverse onus type of proof. That's the way they deal with things. It's the assignor's job to prove that they don't have to pay. Otherwise, by default, they have to pay. And it's tough to prove something that doesn't exist rather than prove something and have the CRA to prove that the assignor should be paying or not. Does that make sense? Yeah. Sorry. Yeah. Normally I like it in the crowd. I can get an immediate sense of people putting up their hands and nodding. This is quite. I'm looking at a screen with a poll and I don't see anybody. It's kind of weird.
Yeah, well, you have 31 audience right now. Just so you...
No, I think if I had next time, I'm gonna get my computer set up better so I can actually have Zoom on my laptop. But anyways,
yeah,
it is what it is, and I'll make sure that I'll get my technology more improved for this thing. This is my first go at this, so we'll make it better next time.
So we have a question from one of the agents, Tiffany.
Yeah.
So she asked if do we pay the assignment amount plus GST to the developer, or is usually included?
No, the assignment amount usually is paid to the assignor, not the developer. But the fees charged by the developer will include GST, but then that's different than the assignment amount. The assignment amount plus the GST is something that is paid to the assignor, like the seller of the contract, the original buyer who's selling it. So the idea is that the seller of the assignment, the assignor, is kind of like a developer. What are they selling? They're selling contracts. Whenever you're not selling something, you're actually only selling a contract, and you're doing it as if you're making money from it. Then, as if you're a developer, then GST is applicable, and so the buyer normally would have to pay. But then the price includes it, so the buyer has paid. It's inside the assignment amount. The assignee has paid it by paying the assignment amount. It's in there. You just have to back it out to find out exactly how much it is. So, $70,000 assignment amount, $50,000 deposit, $20,000 lift. The GST is on top of the whole thing. But if it's included, you just back it out. 70 minus the 5%, and that dollar figure is the GST that the assignor, the person who has the original contract, has to remit that to the GST office. Does that answer your question, Tiffany? Sorry, I can't see your hand. So
Yeah, let's just say it does. Oh, she said yes. Okay, so we have another question from Aaron. Aaron asked approximately what percentage of the purchase price assignor needs to charge as GST for pre-development property upon assignment. Is there a list of tax percentage targeting assignments for reference?
It sounds like the question is about what tax considerations should be considered by the assignor, right? Is that?
I
Yeah.
believe so. Yeah.
Well, in this situation, like we're only dealing with the GST, and the GST is only right at this point the assignor has to deal with is the assignment amount. Now, here's a double taxation issue that may happen, and this could be a scenario. Say the developers normally, and almost I haven't seen any developer that would allow the original buyer or the assignor to be released from the contract, even if they assign it to a new buyer. I haven't seen anyone that allows that to happen. Let's just say, okay, the assignor has remitted the GST to the GST office from its assignment fee amount. The assignee pays $80,000. He deducts that 5% out of the $80,000, and he remits it to the GST as he's supposed to do. Then he sits. Now the assignee goes on, and completion is like 6 months down the line. The assignor is never released from the whole contract. If the assignee then backs out and doesn't complete, the developer then turn around, go back to the original assignor and says, look, like the assignee is nowhere to be found, you're responsible. The contractual arrangement is that the assignor is not released from the contract, even if the buyer doesn't, the assignee doesn't complete. Now you have to pay the price of the whole development price on the contract and GST on top of that. So the basically the assignor has paid a chunk and remitted the GST based on the assignment amount, and then on top of the whole entire price has to pay GST on top. Does that make sense? Iman, is it Iran or sorry?
Aaron, yeah, Aaron.
Aaron, sorry, Aaron, yeah. So yeah. They're potentially an assigner, then at the beginning it would only be the GST on the assignment amount, but later on if the assignee doesn't complete, then the assigner has to step in turn and complete the deal and purchase and pay GST on top of that as well.
Mm-hmm. Okay. So questions from Min. It's the assigner has to pay GST twice, once an original purchase and the second time when assigning?
No, unless that situation I just mentioned happened. So they just have to pay the assignment, the GST on the assignment amount. Later on, when the project completes and the assignee buys, there's no GST applicable again on the assignor. So you don't have to pay twice, but only if the assignee, the person who bought the contract, doesn't complete, and then the developer goes back to the assignor, hey, then there'll be a double GST purchase payment on that time.
Okay. So if the assignor does not complete, the responsibility falls back to the assignee. Doesn't the price goes back to the contract price?
Yeah, it's back on the contract price. Now the idea is that when the assignee doesn't complete, well, normally the assignment amount's already gone, right? The buyer's already got his chunk, his lift, he's got his deposit back. There's not much of a loss in that sense. But what you get is a surprise. Maybe you weren't planning on buying. Maybe the assignor wasn't like, oh, I've got my lift and I wasn't never planning to buy the whole thing anyways. I've got my lift, I paid my chunk of GST. But then the whole idea is that all of a sudden you might then, you'll be on the hook all the way through. And something to think about in this situation is quite often, and if there is, if later on when you look at the 3 standard release of the assignment amount options in the standard agreement, one of them, the option B, and I'll talk about that later, it says the question comes, in terms of the amount, if the assignee doesn't complete. Now, the assignor mostly, in most situations, will keep their assignment amount. But if the completion doesn't happen because of the assignor for some reason, then the assignment amount is, the amount paid, if there's a deposit maybe, or if it's kept until the end of the completion date, should be given back to the assignee. It's pretty rare that would happen. Think about it, like if the assignor has transferred the contract to an assignee, it steps out of the picture, what could the assignor still do wrong that would cause the whole development to collapse at the end of the day? Unusual, pretty rare. For the most sense and purposes, the assignor, the person selling, has the benefit of the contract already, in the sense that it's already got its lift, except that it's going to be all of a sudden a big surprise and you get 10 days notice. Hey, the assignee's never been around. Maybe the assignee didn't even give the maybe another deposit that was required, doesn't communicate, it's gone. Maybe the assignee, and this is something you have to worry about too, if the assignee is a non-resident assignee. You have someone who's non-resident in Canada wants to buy an assignment, then the chances of enforcement of an assignee to actually finish the completion is harder, because they're not even around to enforce, right? So.
Okay, so question from Tiffany. Just to clarify, the GST is only applicable on the lift part. If there's no lift, there's no GST involved?
No. The GST is on the deposit and the lift. The assignment amount includes two things: the lift and the deposit that's being returned back to the assignor. Now, if there's no lift, you still pay GST on the deposit, because the buyer's still paying money back to the original assignor. There's GST on that deposit, which is basically part of the assignment amount. The assignment amount consists of two portions: the lift and as well as the deposit. So the deposit is, even if you say, for example, I'll give you a situation. The buyer, the original buyer of the contract, puts down $20,000 deposit, and then in turn really wants to back out. Oh man, I can't complete, situation's bad. Is even willing to suffer a loss on that deposit, so that he sells it for $10,000 with no lift. It's basically at a loss. But what is the assignee paying? $10,000 to the assignor. GST is payable on that deposit, because it's GST on the assignment amount, no matter how much it is. Okay, so that should answer that question. It's not just on the lift, it's on the lift and the deposit that's being given back to the assignor.
Okay, so Aaron said, thank you. And then there's another question from Matthew. So when we're saying GST on assignment amount, is this assignment amount the same as on CPS, which is paid deposit to developer plus the lift?
Yeah. Well, yeah, that's right. Deposit and the lift, that's right.
And the lift, right? Okay.
Yeah, and the lift, yeah, that's right.
Okay, another one from Jonathan. So he wants to confirm for resale on brand new unit. After already completed with developer, seller is responsible to remit for GST again on the resale as it was not occupied.
Yeah, that's unfortunate, because the CRA's view is that the buyer never originally intended to buy this place, and always as if is intended to resell it, and therefore there's no exemptions from that GST. Say, for example, if you're intending to buy it and live in it, and then you change your mind, and then the CRA would say, hey, there's a rebuttable presumption, the reverse onus. We don't think that you originally intended ever to live in it. You always intended to sell it after you buy it, and therefore GST is applicable. And you might, and the idea is that if you have a contract and there's a question about it, presume that it has to be paid, and then the buyer, the seller who, the idea is that if you want to get a GST to give a clearance certificate, you can do that, but you have to give yourself 3 or 4 months to do that. So the situation is the buyer comes in and says, hey, I don't want to have to pay GST on this brand new unit that was just purchased and now is being resold. But then how do you know? Well, you get a clearance certificate from Revenue Canada. You get an advance opinion. You send all the circumstances and you send it to CRA. They don't, you don't know how long they will take to consider all the circumstances and then give an opinion. It is applicable, it's not applicable, because this is a good idea of whether you can rely on it. But for most people not willing to wait for a CRA as a subject removal, if GST is payable or not, then what, right? Who's to pay it? The presumption is, and advising anyone is that GST is applicable, unless some kind of exemption is given by the CRA. Does that answer your question, Jonathan? So, yeah, there is GST, and the GST has to be paid to the seller, and the seller then has to remit it to the GST office. The CRA. So
the seller pays the second GST.
Well, the buyer would have to pay it, but then they have to give it to the seller, and then the seller would then have to remit it to the GST office. The physical act of payment is usually the seller, but whose pocket does it come from would be the buyer.
The buyer pays first, and then the seller remits.
Yeah, unless you put in the contract that the purchase price includes GST. And if I was ever to be acting on behalf of a buyer of a pre-sale contract or a unit that just completed and turned around, I would advise you put that in there. GST, just like the way the assignment contract for pre-sales includes that section that says GST is included in the assignment amount. If you were to represent a new buyer, always put that in. GST is included in the purchase price, because you don't know if you don't want to. How is the seller able to prove what the intention of the buyer? How is the buyer ever able to prove what the intention of the seller? It's very difficult. You don't want to go there, right? Does that make sense? So if you put in the offer to purchase from behalf of the buyer of a brand new pre-sale that just completed that nobody's lived in yet, GST is included in the purchase price. You never have to worry about that. Now, if you don't say it, if it's silent, is it absent, and somehow the contract didn't put it in, yeah, the buyer's on the hook.
Mm-hmm.
The
better be specified.
Yeah, the buyer has to pay, the seller has to charge. Now, CRA would go after anybody who doesn't do their job. Buyer, you didn't pay, I'll go after you. Seller, you didn't collect, I'll go after you. So the buyer's supposed to pay, the seller didn't collect. The CRA would choose who they want to go after. Hey, seller, I'm going to freeze your account because you should have collected the GST, but you didn't. You should have remitted it, but you didn't. And you have to prove me that you shouldn't. Or, and sometimes I think that CRA, you don't want to deal with CRA. It's like, if you were a CRA, think about it. Who would you want to go after? Whoever is easiest to go after. Someone who's resident of Canada, someone who has assets, someone who has a bank account, who has a business with assets to go after. Okay.
Okay, so we have a question from Cindy. I heard that a seller already paid the first GST.
Yeah.
And then paid the second GST when sell the condo. The seller is able to apply to get a refund on the first GST. Is that true?
Not on the first, probably not on the first one.
The second one?
Yeah, if the seller had to somehow pay because they didn't consider the fact that they were, for example, let's just say they give evidence as to the fact that that they had always had intended to live in the home, but couldn't. So say early on they had, I'll just give you a sample scenario. the initial contract with the developer has the assignment clause, which the developer has accepted. The purchaser has the right to assign his or her son or daughter to the contract anytime prior to completion without having fees paid to the developer. Now you have the intention of the buyer, the assignor maybe, right up front. Hey, and what CRA would look for is evidence that would be consistent with the intention of the person who's saying that they shouldn't have to pay. If there was never, say for example, down the line, they buy the property, but they're always thinking of buying it for their son. And then in the end, the son, decides to go to university in Australia, or whatever. Don't go to New York. Oh my goodness. But anyways, and then all of a sudden, they say, hey, our original plans changed. Now we have to buy ourselves and rent it out. But we always intended to have our family live in it, not to sell it. Now you give all that evidence and you prove it, including right from the original beginning with rights to assign. That's evidence that proves the reverse onus clause, that you have to prove that it wasn't your intention all along to resell this place. Does that make sense? Yeah. So yeah, there are ways to after the fact, of after paying, to see if you can get a refund, but then you have to prove it. But finding evidence like that, like say the I don't know, you're thinking of buying this place for your parents, and the parents decided that, hey, we can't own a house because it'll disentitle us to benefits like CPP or old age pension. It reduces the amount if you own real estate. All these things which have other people's involved, like family members. And the more evidence you can get, the more you be successful in doing the reverse onus proof that CRA requires. For that matter, like sometimes I had someone who says it's they claim for the GST rebate because it's their principal residence. They apply for the rebate after they bought it, and then they change their mind. They're going to sell it now and then the GST office will say, hey, you got a rebate. Now you're saying you're not living in it anymore. Therefore, we think that you have to pay and refund the GST, not refund, but pay the GST that you got an exemption for. You paid a partial amount, now you have to pay the rest. And then what they'll look for is evidence that the person never lived in the house, never intended to stay in the house. So, even if you apply for a GST rebate of some sort and then have to change your mind, then you have to reverse onus to prove it. Okay. So was that a question from Jonathan or Matthew?
Yeah, that's a question from Jonathan, I believe.
Yeah. Okay. Yeah. Does that answer your question there, Jonathan? Kind of long-winded, but I wanted to give that example and to talk about it more, because GST is a whole different. The CRA office and dealing with them is a whole nother matter. Of course, I wouldn't advise agents and licensees to give GST advice, to talk about what is applicable, how much to pay, refer, hey, you should seek an accountant, seek legal advice, and this is quite standard, and you should put that in your agreement that the buyer is and the seller too are both agree to check with their own advisors about this issue. Okay, it's not something you want to get involved with. So you're not accountants, agents. You're not dealing with how to prove CRA's reverse onus clauses, and how do customers who are sellers or buyers deal with CRA.
Okay, there was actually a question from Cindy. Mix it up.
Sorry, does that answer your question, Cindy?
Yeah, we start to get more and more questions. Don't worry, guys. We'll be here until 5 p.m. Right, Ivan?
Yeah. My battery's running out. I gotta charge it. Yeah.
So we got another one from Tiffany. So what is a good clause to say that GST is included in the purchase price?
Oh, exactly that.
I think, yeah,
You know,
yeah, I think we just go with it.
exactly that. The buyer and seller acknowledges and confirms that the GST, if payable, is included in the purchase price. Yeah. You know, and the seller may reluctantly say, "Hey, it's not payable. I don't owe it. There's no way that I should owe it." Well, then put that in. If payable, if it all is payable, is included in the purchase price. So you know, instead of saying it is included in the purchase price, which makes a lot of sellers get upset and say, "Hey, what's going on?" Da 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 da. Well, and you know, you put it in. If it is payable, then it's payable by the seller.
He says sale price is final and includes GST.
Yeah, includes GST if applicable, right?
If applicable, yes.
Yeah, yeah.
Okay. Jonathan, are you able to apply for a GST rebate if the property is over 450,000?
As far as I know, no, because there's a limit on that. So there's a limit on the price that you pay. So if the prices are too high, they don't think that anyone needs to break on the GST. So it's not like an exemption. It's not an exemption type of thing, reverse onus. There's no rebates at all live based on the purchase price.
Okay. So from Sissy, if you cannot prove your intention, you have to pay GST twice then?
Yeah, that's right.
Okay. Straightforward.
Yeah.
Okay. I think no more questions for now. You want to keep going on with your slides?
Yeah, sounds good. So we go to the next one now. The next slide on page 20. These are the we briefly mentioned it, but I just want to bring it up on the screen. Like, you know, because the actual contract is like, I swear it's like 2-point font. You know, you get a magnifying glass to read it. But what on earth does it actually say? So I put it there on screen 20, but then on the next 3 screens, I've blown it up and highlighted certain. So if you look at 21, I have option A with some items bolded so that some important words that looks like gobbledygook when you look at it from a tiny font. But I want to highlight some of these things. So the first option for the dealing with the release of the assignment amount. So option A, assignment amount is released on submission for registration. And registration means the actual completion date of the project when it's ready to transfer ownership from the buyer to the assignee. So that's when the assignment amount, which is the deposit plus the lift and any GST that's included, all that stuff is to be released at that point in time, all the way down the line. Now, if you got a assignee or assignor in this situation and you're thinking which option to choose, if it's like only a month away, you know, like your buyer, the assignee has purchased an assignment, and it's only a month away from the actual completion date, then you might want to choose this option because it protects everybody, both the assignor and the assignee. Nothing happens until the actual day of completion. Everybody gets paid, for commissions get paid, the assignment, the lift gets paid, the deposit gets paid, the purchase price gets paid, the buyer gets their house, gets their condo, their townhouse, everything gets done on completion. But it's quite often, if you have, you know, developers don't sometimes tell you when one of the operating words is, you know, no, not yet, we're gonna extend it another month, next month. I'm sure all of you have dealt with developers and pre-sales have dealt with that issue of extensions all the time. If you actually don't know, you're not sure, and it could be months and months and months in advance, you might not want to do this because it doesn't, because the further and further away the actual registration happens, the more the more I would say that there's more risk involved. Choose option A if it's really close by, like within time, right? So here, in option A, it says the assignment amount once paid, when all conditions of any are waived and satisfied. So, subject conditions such as subject to financing on behalf of the assignee. They've got their financing in place. Everything's all good. The developer has consented to the sale, and all of a sudden, okay, the money, the assignment amount is given, and then when it's going to be released, well, registration is happening just around the corner. So the assignment amount is given to the stakeholder, like the real estate agents or the lawyer.
Who is the stakeholder?
Yeah, stakeholder. Yeah.
Is the agent?
Yeah. Most likely, in most situations, would be the stakeholder. They would be the real estate office, the brokerage.
Okay.
They hold it, and then when completion happens, everything gets transferred. Everything gets given. Assignment, which means that the assignee has bought it. There's no default there. Then there's no more concern or worry from the assignor that they have to step in place of the assignee and continue on with the deal. Everything happens, then everybody gets their money. The developer gets their purchase price, the GST office gets their GST, the assignor gets their lift and get the deposit back, and buyer gets their property. Okay, and then when that happens, when it actually completes, when the transfer is being transmitted for registration, and then they have another section of this. If it does not happen, then everything is be returned back to the assignee. So the assignee gives it to the stakeholder. For whatever reason, it doesn't happen. For whatever reason, it doesn't specify whose fault it is. It just say it doesn't happen. Then it's given back to the assignee. Now, one of the things about this this last clause is, and that's where all the litigation sometimes happen, is whose fault is it? Like is it the assignee's fault, assignor's fault, that the completion date doesn't happen? It didn't. The standard form contract doesn't say whose fault is whose. It's just that if it doesn't happen, it goes back to the assignee. It's as if the contract didn't happen at all. But it may sound unfair to the assignor. Hey, it's not my fault. But this is not dealt with by this. And anytime you deal with an option A, you get what you get. And if you don't want it, you don't like it, then you need to do something like an option D, that you do an addendum to deal with that issue. Okay. Now, next page, 22, option B, the assignment amount is released on subject removal. This is quite often the most common condition that I've seen, and not the only one, but the most common. So what happens is the assignment amount is given to the real estate agent. They're waiting for the developer to approve, but the completion, for the actual completion of the project, maybe a year and a half, or 2 years down the line. The assigner doesn't want to sit around waiting. Hey, I want my money. I want to be able to take it and move on and deal with it. So in this situation, when subject's conditions are waived or satisfied, such as, for example, the most important one, the assignee gets financing for the purchase and gets approved, and the developer, this most important one, the developer has approved the assignment. The assignment fee has been paid and everything, all that. And then that's when the assignment amount is released, like the lift and the deposit is given back to the assignor. And now the assignee stands in the place of the assignor, now waiting for the deal to complete. The assignor has their money and their lift, and they're gone. Not gone completely, because the developers don't ever release them. It's not, but they got the money. In the meantime, the assignee sits and waits for the developer to let them know when a completion happens. This is one of the most common things. And of course, during this time when the assignment amount is given to the developer, to the assignor, any commissions payable are released retained by the stakeholder or brokerage and then the excess balance is given to the assignor.
So does the realtor commission get paid after subject removal?
Yep, that's right. Yeah, when subject is removed, the real estate commissions are paid from the assignment amount. And that's why, and that's why it's good to have, like, some people might say, hey, I want to have my lawyers hold it. The assignor and their assignee says, I want to have my lawyer hold it. you know, if that happens, you know, the automatic payment of your commissions may not happen as quick. So you want to have have your office to be the one that holds that amount as a stakeholder. Okay. I highlighted at the very bottom of the assignment amount shall not be returned to the assignee except if the problem was due to the assignor's breach, and that's pretty rare for that to happen. So, like for example, invariably in this situation, if completion doesn't happen, and the assignment amount is not the fault of the assignor. Like he didn't do anything wrong. He sold everything. All the disclosure statements were given. The subject's removed. The buyer's got financing. He's got his lift. He's gone. But when and what situation would the assignor have to give the money back? Well, only if it's their fault for the completion not happening. And this is what is written down here. The assignment amount not to be returned to the assignee, except where the developer's failure to complete is the construction of the property, complete the contract is due to the assignor's breach of the assignment agreement or contract. In some rare situation, that may be the case. I can't think of one. If the assignor misrepresented something on his application for some reason, like the assignor says, I can't think of a reason, but whatever the reason is, it must be really minute or not happening or very small, because I can't think of one where it would still be the assignor's fault for the completion not to happen. So invariably it'll go back. There'll be it's not it'll be returned. Shall not be returned to the assignee. Is kept by the assignor. Okay. Then you go to the next page. Next slide. Option C. Sorry, page 23 of the Adobe. The portion of the assignment amount released on subject removal, a portion of it is released, and the balance is released on submission for registration. Now, quite often this situation, what's being given back to the assignor is his own deposit. He makes the lift when registration happens, but at least he didn't lose out on his deposit, because this is the normal thing. So once assignment amount is given, all conditions are waived, or met. The assignee has their financing. The portion amount equal to the deposit paid the assignor. So they're out of pocket when they first bought. They get that money back, and that gets back to them. But the lift is held until the the completion actually happens. This protects both people. It's like a hybrid. A hybrid where at least the assignor may have lost his deposit for use of it, but he gets it back. He's waiting for his lift later on. You get something back, not nothing back. And then the rest of it is given, and this is where I highlighted it, upon the transfer of the property being transmitted for registration. And that's when the lift goes to the assignor. But then it says, what if something happens? What if it still doesn't complete? Then the assignee will then have the option. The assignment amount is released to the assignee. So, the assignment amount, well, what's the balance there? The deposit has already been given. The lift that the buyer had paid and put into trust gets given back, and then the agreement is done. Okay. Now again, what this doesn't say or do is deal with whose fault it is for the completion not happening. It's just, hey, it doesn't happen. It doesn't happen for whatever reason. This is how it's dealt with. So anytime you want to go beyond that or go outside of that and attribute blame or fault or causation for the completion, the developer didn't complete, the developer couldn't complete, or for whatever reason, the assignee, and you have to add some things in. Like if it didn't happen because the assignee, say for example, they waived their requirement to have financing, thinking that they had enough money, and then at the end of the day, they couldn't complete because they didn't have enough money that they thought they did. Well, it's not fair because they get whatever they paid back. The property was tied up. Anyways, there's a lot of litigation that could happen as a result of that. But and I think if you want to add those clauses in, it's going to be quite pretty convoluted because you have to count for a lot of situations, whose fault is whose. But for the standard form contracts, this is what they say. They're not trying to say who's to blame, basically, except for if the assignor had to blame. That's option B. Assignor did something wrong, couldn't complete. It's pretty rare that happens. I think the whole point is to avoid getting into attribution of blame mostly. It's just say, hey, it doesn't happen, sorry, it doesn't happen. So these are the three standard ones. Now, if you want to go beyond these, you have to be very careful. You have to, those at the very beginning, I gave some essential things to think about when it comes to assignments. If you cross out any of these and you do your new one, you have to make sure all those things are considered. What situation would be when the assignment amount or part of it or all of it is given, and when it's to be released, who's going to hold it, and how much of it is going to be held back. And if someone's fault is for doing something wrong and it didn't complete, who would pay for it, basically? Who would be responsible for that? Either they lose their assignment amount or get the assignment amount back. So and put that all in if you want to move. Now you might want to do an option C, copy it all, but add a few conditions to it. That option B, amend it, but cross it off, but reword the option B so everything that's inside is kept. If you want to add a few things or tweak it a bit, but you don't miss or take out anything. Next slide, what are some sample wordings for an option D on slide 24? Slide 25, you have to deal with things that may come up, which the three options don't deal with. Non-resident assignors and holdbacks, and I'll deal with that in a minute. Like if you have an assignor and you have a buyer and the seller is non-resident, you might want to add some terms in. You want to still keep those things about deposits and assignment amounts and the lift and the commissions and when the registration completes or not, but you need it all. But you may want to add something to deal with this situation. And it doesn't mention anything about how those assignment amounts and deposits are supposed to be given. You might want to deal with bank draft or certified check or wiring the funds. And then also in another section, maybe you don't like the way those clauses in those option A, B, and C deals with what happens if it doesn't complete. Like, you want to have some, like that situation that I just mentioned. If the assignee waives conditions, subject conditions, and then, but really shouldn't have, but didn't get financing or whatever reason that they couldn't complete, and that's the reason why, and the assign, normally that wouldn't happen because the developer would just then turn back and go to the assignor and say, hey, the assignee couldn't complete, now it's your turn. But hey, think about it, right? The assignor is in the middle on a cruise. Oh, sorry, bad word nowadays. Don't be on a cruise or whatever. You're on a cruise, you can't make it back in time, you can't get the financing. Wasn't thinking about it. Yeah, no. And so then you might have that situation, right? So, anyways, you want to have some things. You might want to have a clause. Now, I came across a contract and I thought it was not bad, pretty good. It's from another brokerage, but it's okay. I just put it here as an example. I just want to highlight it. So if we go to clause number 20, page 26, I'm not sure how the font would look, but I want to read it. So I'll read it out to you. This is dealing with the assignment amount. This is an option D that was given. I'll read it out. A deposit of $80,000. The deposit is to be paid to, in this particular case, Sutton Group West Coast Realty, the stakeholder, in trust by way of a bank draft or wire transfer. So then you highlight the words of how it's to be paid upon final subject removal. Using final subject removal, it seems more colloquial. It's, instead of saying all conditions are waived or met, subject removal. It's a very, everybody understands what that means, right? The deposit and the remaining assignment amount, so the remaining assignment amount, whatever that is, right, will be released to the assignor or his agent or representative or legal counsel. So you have a choice. Upon submission for registration in the appropriate land title office. And then add this phrase here, subject to any holdbacks required by law. Now, so add this clause in if you have a non-resident seller, right? Because there will be some certain holdbacks, and I'll talk about what holdbacks, and how to calculate the holdback, and how is it done later on. If the purchase of the home, as defined in the contract, does not complete by the latest date specified in the contract, of course, you know, that's why you put that clause in case, you know, for the developer always postponing dates here and there. At the option of the assignee, the deposit is to be released to the assignee, and this assignment agreement shall be terminated. And then this is a section where it deals with, unless the assignee is the sole cause or reason for the non-completion. Earlier I mentioned, well, what if the, you know, it is really because of the assignee is not, you know, with all the subjects removed and supposed to complete for whatever reason, it doesn't matter what reason, can complete, and the assigner, you know, whatever reason, they're the cause for the whole thing to have to collapse, then the deposit will be forfeited to the assignor. See that the other ones don't really deal with this situation. You might want to have the fact that, well, why should the assignee get back you know, everything? At least that the deposit is given to the assignor if it's the fault of the assignee for not completing. Now, if you look at that, the wording that they use here is sole cause or reason. Now, assignee, I think the wording should be better, unless the breach of the contract is because of the assignee's fault, or his but not the assignee is the cause or reason. But here it says the sole cause or reason, because many times there's many causes, but it's all related to the assignee. Then you're attributing. It doesn't matter what the cause is, where it's from, or how many of them there are. Like, say for example, financing. The bank did a problem with their with their approval. The bank didn't think, or the agent for the mortgage broker didn't say that the guy was married with a spouse that's overseas, and they needed someone signing with an ILA saying that, you know, whatever, and then the bank doesn't pay the money after all. Is it the assignee's fault? No, it's the bank's fault. But so then you say anything to deal with the assignee, it doesn't matter. It's not the assignor's fault, no matter what. And so that's why you have this clause. It doesn't matter what reason it is. It's because of the assignee, something to do with the assignee. And the assignee can say, hey, it's not my fault. The bank screwed it up or whatever. Anyways, and so then you add that clause in. And then the extra thing about the commission, the assignee and assignor acknowledge all commissions are to be paid at completion. You might want to have that subject removal, or you can have a completion. In this particular case, there's only like a couple of weeks from the time of this assignment contract being done and the completion of the actual project, and it was already been decided what the completion date was a month and a half before. So, you know, in some fortunate situation where you have the completion in sight, the developer has issued their notice, and then they still approve this assignment, right? Okay. Anyways, just an example. I want to go to the next screen because it just has a sample of things that I've highlighted here. You know, there's an extra line there too, saying any administrative charges or costs charged by the developer. In case you do more, like we mentioned at the very top of the whole discussion. What if they change their fees? Well, what if they say you have to pay for wire transfer cost, you know, or you have to pay for, you know, them certifying your whatever, your check, if they allow you to pay by a regular check or whatever. You just cover anything and everything the developer charges that's part of it. And then the method of payment, and then any holdbacks, and anyways, so I mentioned that. Now, on the topic of holdback, I want to maybe skip a few pages and deal with the holdbacks. Now, I think I had a poll about how many of you out there who have dealt with assignments have dealt with non-resident assignors. you skip to that. I don't know if you have that poll handy.
Yeah, it's mostly they have done with local assignment.
Yeah, right. 86%. Oh, that's good. That's a lot. Actually, on my screen now, I'm looking at the GST poll. I don't know if I can get the. Anyways, now you have a non-resident assignor. I want to talk about that, and before I go back to assignments, if you don't mind, if you put the screen, my Adobe presentation to page 29. So what happens if assignors are non-Canadian tax residents or were foreign buyers? So go to the next screen, page 30. Oh, CRA clearance certificate to be applied by assigner. Now, what is it? What needs to be done? And I want to talk about this a bit. So what a non-resident assignor has to pay a tax on the money they receive for anything they're selling. So that selling, includes the deposit, includes the lift. They're getting money from somebody. GST is applicable on that assignment amount that we talked about earlier. And then there's something called a withholding tax, which is tax on non-residents for anything money they receive. And and then CRA income tax, that money they receive covers a lot of different types of money. So if the buyer gets say, hey, you get the purchase price and I'll throw in a car, whatever. It's anything that monetary value that they receive as a non-resident. So in order to find out how much they owe, an accountant or an application has to be made to the CRA, who determines and looks at all the documentation and determines how much money is to be given. And then once the amount is given, then a clearance certificate is issued, so that there's no more obligation that anyone has to pay for the withholding tax. Now the assignee says, hey, I don't know if this guy will pay, because just like the GST, the CRA will go after anybody who's supposed to hold it for them. The CRA makes the Canadians the tax collectors for the government, and that doesn't matter if it's the person who's supposed to pay, the person who's supposed to collect, the poster, so they have obligations for everybody. So in the CRA it says that the seller, has to pay, but is the buyer responsible for anything? Well, the buyer would then have to, by law, they're allowed to, and they should, hold back. Now, what is that amount? It's 25% of the assignment amount. This is including the lift and the deposit. So you put those two together, what is that percent? If someone says, hey, I'm not even making a profit, I'm just selling at getting my deposit back, or even less, well, the assignment amount is still either includes the lift. If it's no lift, then it was a deposit. Any amount that's paid for the price, that's there's an assignment. There's a withholding tax, 25% to be held back. Okay, the part of the Income Tax Act that refers to this is Section 116. So so when you draft any agreements to deal with the non-resident holders, you have to talk about this issue, that the buyer is entitled to have a holdback of 25% of the assignment amount until the assignor has a clearance certificate, and then it's released. Now, the third bullet point is 2 or 3 months on average. Technically, the seller, the assignor, has to submit their application on the 15th day of the month after the month in which they sold the property. Then it takes 2 or 3 months to get it. So you're waiting for a long time. The holdback could be sitting around for quite a while, waiting for the CRA to respond. And that's why you need lawyers involved, because this is something that the lawyer for the assignee has to make sure that the assignor does. If I was the lawyer, now, like, the question is, as long as there's lawyers involved with holdbacks and something called undertakings in place, and make sure the wordings is good enough to know who is responsible to do what. And the holdback can be held by the assignee's lawyer or the assignor's lawyer. Normally, the assignor lawyer holds it as long as there is sufficient undertaking agreements between the two lawyers, the assignor's lawyer and the assignee's lawyer, to hold that amount, and what conditions are there when that can be released. And normally that is when the assignee's lawyer receives the CRA clearance certificate from the assignor's lawyer, okay, then now you can release it. And proof of payment of whatever amount has to be paid has been paid, okay? Because the clearance certificate isn't issued until the amount that's supposed to be paid is actually paid. Okay, so I'll give you a scenario. Completion happens for the assignment. Say there's an $80,000 assignment amount, and that's given to the stakeholder, but then, and depending on the option that was chosen, a certain amount is given to the assignor's lawyer. Take out the, let's just say that the commission is 10,000 out of the 80. The commission is taken, 70,000 is given to the assignor's lawyer. And let's just say that the assignment amount is to be given to the assignor on subject removal, which is like option B. Okay, well then it's not completely given to the assignor. The lawyer has to be, the assignee's lawyer would have to say to the assignor's lawyer, hey, this is a non-resident assignor. You undertake to hold back 25% of the assignment amount until we, the assignee's lawyer, receives the clearance certificate from the assignor's lawyer, and that upon which then the holdback can be released to the assignor. Now with an undertaking, that means that the lawyer has to promise and hold back and stick it in his own account, trust account, while waiting for it. Now the buyer, as long as this is done, as long as there's a holdback done, the assignee is not liable, is not at risk. If nothing is done, this 25% of the holdback is not held back. The CRA can go after the buyer, the assignee. Look, you're supposed to hold it back. You didn't. Yeah, now we're going to go after you for it. And that's why it's important to have these protections and holdbacks in place.
So at the bottom last line there, it says for non-pre-sale. Do you mean non-resident pre-sale?
Actually, no. What I'm talking about is when it comes to yeah. Did you say resale? Sorry, it was kind of
at the bottom of the point there, last point. It says non-pre-sales.
Yeah, actually, what I wanted to say for this one is, if the seller is, this is where it's important about intention. For 99% of these situations, the assignor is like an individual. But if this individual is like someone who goes and it's his business to go and sell pre-sales, assignments, and it's their business, and they get, and they have a company, and the company is the one that's doing it, the CRA may look at this seller, this assignor, and say, hey, you're just not a non-resident, normal, typical assignor. You're actually a developer. You're in the business of selling pre-sales. Therefore, when you sell your 5 or 6 or 10 or 15 pre-sales that are in your disposal, we call that inventory. And if you call that inventory, then it's a 50% holdback, not a 25% holdback. Does that make sense?
Yeah, it does.
Yeah. So they have a different standard based on the degree in which the assignor is considered just like a person. Most typical situation, like a buyer signs one property, or they're doing this and they think that this is their business. And then they equivalate them, and they say you're not just a person buying a place and then changing their mind. You're not just a person originally sending it for your kids and then now you're getting it, keeping it yourself. You're a person who does this on purpose, intentionally as a business. You are in our eyes a developer, and the holdback for the assignee is then 50%. So you make that because that's in the act, but it's hard to determine what it is. For the most part, 99, and I've never had that situation where somehow the assignee hold back 50%, because they think that the assignor is someone who does this as a business. Okay, but the law in the CRA is that really, it's up to the assignee, the person who's at risk, when it comes to a non-resident assignor, to hold back amount that's sufficient for its purposes. It has to be reasonable. 25% is minimum. But if you want to do more, it has to be reasonable. Okay, so anyways. Any questions there?
No.
Yeah. So, actually, I'm trying to think about slide to go next. Maybe just to go back a little bit about one of the kinds of risks that are involved in an assignment. We touched on it over this whole time with different questions about, and what happens if the assignee doesn't go on and complete, and then the assignor is at risk of having to step back in place. This happens for pre-sales. When you do resale, that you can negotiate anything. You're not up to the developer's rules. If the assignor and the resale says, hey, you know what, I don't want to be responsible. Once you take this and assignment amount is released and subjects are removed, no more liability from the assignor. You can write that into the contract, and if you are representing the assignor, that's what you prefer. If it later on doesn't complete for whatever reason, the assignor has no responsibility at all whatsoever. They're out of the picture. They get their assignment amount, they're gone. If that's for resales, you want to protect the assignor. They don't have to jump back in place. But for pre-sales and developments, it doesn't usually happen because it's not allowed. The developer doesn't want to release anybody. So, okay. For the assignee, what they're risking when they buy these assignments is, what if the developer doesn't complete? What if the developer, this happened to the project a year and a half ago in Richmond, where they just said, hey, everybody, we can't finish building, we ran out of money, sorry, give your money back, your deposits only. But what if there was a lift that had happened prior to that happening? If the deposit amount was given, all of a sudden, that's a risk that the assignee has. Okay, I just want to touch on those two things, but when it comes to non-resident assignors, there's contractual wordings and undertakings between lawyers that could help with that risk of that tax. So that can be, make sure that that your lawyers are aware of that. I've actually had situations where the assignor, I think the lawyer didn't think that it was required for them to do that holdback. And they give all the monies to their client, and no, that's not only a tax issue, because the undertakings were required or placed, but they just didn't listen to it. The buyer, the assignee, isn't responsible because they've done whatever they had to do in order to ensure that and that's all they could potentially do besides holding it back themselves. And that sometimes happens, like the assignee's lawyer holds it, and there's no way for it to be given away to the assignor by accident, by negligence. Somebody who's not aware of the rules, the assignee holds it, and so, and then for sure it's not going to go until, because the assignee says, hey, I don't got my clearance certificate, I'm not going to release it. Anyways, and just something to put out there. And I'm going back to slide number 34. Now, slide 35 says about what are other tax implications of an assignment. I just want to go over this briefly. So page 34, we did talk about this, the first part, GST. It could be double pay, so people have to be aware of that. But you also have to think about the property transfer tax. And when you are representing assignees, so people buying it, you will be asked questions from your clients. Hey, how much property transfer tax do I have to pay? When they have to consider their financing and how much money they have to have ready for completion. So the property transfer tax is 1% of the first 200, 2% of the rest. There's and higher percentage, more over 2 million. But if you add a lift to it, and this is how the Property Transfer Tax Office will calculate the PTT, you have to add the lift to the contract purchase price, choose, and then calculate the PTT on that amount, not just the PTT on the contract amount. Okay, and the idea is that the property transfer tax rules say that is how much you paid as a buyer for the property. Well, you didn't just pay the contract price, you paid the assignment or the lift to the assignor. So what you actually paid is the lift plus the contract price. The problem with that sometimes is like if you have a buyer who is counting on their exemption for the first-time buyer of a pre-sale because they're going to live in it, and the maximum amount for that is $750. The lift, say for example, the price was $745, the lift was $50. The total price would then be $795, and so therefore they're no longer exempt from that exemption from the paying the PTT, and all of a sudden they have to pay the PTT. So so that's something to be careful about when it comes to these. When you're advising your buyer about the consequences of buying an assignment, they have to add their lift to the calculations of the PTT. So that's something else to think about. I just want to draw that fact because it does happen, and you don't want to have a buyer who didn't calculate that, and then they're short of money on completion day. And they go, oh my God, we're going to find another whatever, how much money that is, okay? So that's the last part over there. The thing about how you can avoid it, well, you know, all the developers, they have, when they get the approvals, this is bullet point 3, you know, developers have to report the assignment amount and the lift to the BC government. So the idea that if anyone wanted to check, it'd be easy. The PTT office would just say, hey, collect that information that's already been collected by the developer, and they know that this person is supposed to pay this much PTT, but someone, when they bought the property, they didn't. They'll go after them afterwards. And there's quite a number of people that would get audited afterwards, and then they have to pay on top. So instead of having it a surprise later on down the line, it's good to have it up front. Hey, look, you have to pay the PTT on top of the on the lift as well. So, okay, that's all. That's all the points I wish to make for today. At the very if you go to slide 35, I just have a little bit more. If some of you may have seen me before, I may have given you my card, you might see my banner, but they don't have my cell number. I've got my cell number there.
And you have the green mugs flying around the office.
Oh yeah, those the green mugs have my office number. That you generally right now I'm practically not in the office for a whole bunch of times because of this self-isolation thing. I've got my rotating staff. I work from home, but my technology is still not up to snuff because of this Zoom. I didn't know I can. I had to talk on the phone instead of the Zoom. But anyways, call me in my cell, text me. For me, this kind of way is if you have pressing concerns and you need a quick look at something to see whether you've drafted something right or wrong, you can text me, throw me text, tell me that you're an agent from Jovi, and that's important for me, so I know if I get a text out of the blue, hey, this is John told me to call you, that's not good enough. Okay.
Too many Johns out there.
Yeah. And don't go away before this, because I have a couple of prizes to give. So don't tune out yet, because you might miss out on a few prizes. So here's my information on page 35. Email me if you want a copy of this PDF. I've given this also to Chris and to Calvin, and so if you need, get it from them. I might revise a bit of this to add some links, hyperlinks if it's an Adobe or PowerPoint. So that you can click to a legislation or section 116 of the Income Tax Act, which is a good thing to read when you're about to sleep. Yeah.
Wow, did I read this right? Contest for $25 gift card from Amazon.
Yeah, digital one. You don't have to come to the office. I don't have to see you. I can email it to you. So there's a couple of So anyways, get ready to input your answers on your chat box, I think. Is it the chat box, Calvin, where people would put answers? It's a question, and then whoever answers closest to the answer that I have in my mind question. But I'm not sure how does the audience type in their answers?
Yeah, we had a chat box here on
the chat box.
Yeah.
Okay. Anyways, there's going to be 3 prizes. So, you know, if you don't get the first one, don't give up. Don't tune out. So it's a pretty. You want to do this, Calvin? You want to set it up? Oh, I guess he's not on. Okay. Is Calvin still there? Calvin?
Yeah.
Oh, okay. You're
Okay,
the
so
controller.
we have 2 questions. Yeah, Ivan, go ahead with the questions. Yeah.
Oh, I think we're gonna do the.
Yeah, we do that last. We do that last. Yeah.
Okay. I'm gonna think of a number from that one. Is that the question? I gave a number of options to Calvin. We're talking about this morning. Number from 1 to 1.
So one of the questions that Ivan has is, which law school did he graduate from?
Oh,
whoever get the answer will get the gift card.
Google time.
Yeah,
Google
so
time, guys.
you might have to go to www.iventse.com and go to the About Me section pretty quick and see who gets it first, and then they get there.
The first one got the right answer. We get it. From the box chat.
Oh, Karen said Dalhousie.
Yeah, yes, right. Awesome. Okay, you have to give me. I can't see emails on this phone, and so the Calvin or Chris or whoever, give me the email later for this. Okay, good. Congratulations. Who's that? Karen? What's your name, Karen?
Karen Wu.
Karen. Okay, congratulations. All right, awesome. And the next one.
The next question is, does the land title office allow video signing of land title documents, like the Form A transfer or the Form B mortgage?
Cody said yes.
So tell me, what's the first person who says no?
Matthew said no.
Okay, Matthew's the first one then. Matthew, you got it.
What is the question again?
Whether or not the land title office allows for video signatures of Form A or Form B documents.
Nice try, Cody. We have a lot of yes.
Yeah,
Matthew
you know,
no.
the actual thing is that they allow some things, but not the Form A and Form B.
Mm-hmm.
So affidavits and support, statutory declarations that are submitted in the course of a, for example, the declaration, but anyways, not the Form A and Form B, they still require in present signing of some form. And there's a way to deal with that, but it still requires somebody in person seeing a lawyer or notary. And I've had to deal with that. I've in the last 2 weeks, I've met clients doing counterpart signatures and then parking lots and cars, and they don't want to come to the office in front of people's houses, but they still have to have somebody. And one of the ways to do it is to have an affidavit of execution, and realtors can do that if they know the signature of their clients, not on a signature on a DocuSign form, but they've seen actual contracts and their signatures and their other documents, and they can come to see me as a lawyer. And the documents have been signed by the client elsewhere digitally by video, emailed to me and the realtor. The realtor comes to me and says, I know this person, I know their signature, and this is their signature on the Form A and Form B, and say that in front of me. And then that will be accepted at the land title office.
Okay, the last one, everybody can participate. It's very straightforward. From the number 1 to 100, Ivan has picked a number. Whoever got the number the closest will win the last gift card.
That's a good one.
Yeah, and you guys can do more than one number guesses, because there's a lot of numbers from 1 to 100, and there's only like 30 of you. So each of you, and then I can't tell this one. So Calvin, you know my number. Whoever gets it first, and this may go for a little while, I suppose.
I think Tim is cheating. He said 1 to 100.
Nice
try.
Oh, that's good. That's a good one. Take it literally. Telling a lawyer to take his words literally. That's pretty good.
We have a lot of numbers now. So I don't know the number, Kevin.
Yeah, Kevin knows my number. I sent it, and I can't see the numbers that are being typed in, so I don't have eyes.
Let me see if I had the luck. I don't know the number, guys. There.
I WhatsApped it to Calvin.
Can you repeat the question? Someone don't get the question.
So there's a number that's in my mind. That number is somewhere between 1 to 100. So whoever guesses the number that's in my mind right now, then that number is like in between 1 to 100 will get the next prize.
So who is the winner?
Just wait, everyone participate.
Yeah, everybody has to type in
10
their
more
numbers.
seconds. 10 more seconds.
And then Calvin has to look and see if the numbers match, and then we're good. So anyways, all I need is Karen and Matthew, right? Karen and Matthew. So you get your emails later on, and it'll be an email gift that'll come through Amazon, and I'll buy the card and email it to you guys, and just send it to me later on. And if we do connect that way too, then you can send maybe your business card and email it, because I can't other than just an email, maybe your contact information too. So.
Mm-hmm.
Okay, so the winner is number 45.
We got a winner. Who is it?
45.
Number 45. Who had number 45?
Nobody has 45.
Anish. Anish, there you go.
There's a
Anish got
44.
45. Anish say 45. Yeah.
Oh, there, Anish.
Yeah.
Congratulations.
Anish, I thought it'd be a lot easier than the other two. So that's good. So you can send me the emails later on. I'll send the gift cards out, and then we'll go from there. Give me and your winners, Anish and Matthew and Karen. You can send me a text and email, and we'll send you the Amazon gift card. And that's it. We're all good for today. Now, one of the things I was thinking for another topic, and you can think about it, is real estate in the context of the COVID environment, how to deal with that in contracts. I don't know if you want to think about it, but I do have a potential clause that I might want to suggest, and I'll send it to you guys, you Chris and Calvin and John. Take a look at it and see if it's something you want to share it or not, and we can think about it for next time. Okay, sounds good?
Okay, thanks, Ivan.
Thank you so much, Ivan, for your time.
Yeah.
Guys, if you have any questions, just call him, text him, or email Ivan. And his information is there.
Awesome. Thanks, John.
Okay, thank you. Thank you, Ivan.
Okay, you guys, everybody, you guys take care out there, really. We wouldn't be doing this if everybody was not safe. So
Yes.
do what you can out there and be safe and take precautions, and we'll see you soon.
That's right. Thank you, Ivan.
Yeah, and then we can have an in-person meeting finally at some point. Oh, geez, my goodness. This is weird.
Yeah, stay safe out there. Yeah.
Okay, you too. Thanks, guys.
Okay, take care.
Okay, thanks. I guess I should I hang up? I don't even know how to hang out of here. Skip poll. Okay, thanks, Calvin. Thanks for coordinating, and thanks, John, for hosting from there. And is Christopher on the line as well? Is he here?
Yeah, he's here.
Hey, Chris. I don't know if you can hear him. Maybe one of the questions I was going to ask is, what does the E in his email stand for? CE Hughes. We didn't ask that, but it's okay.
Yeah.
We'll find that out later. All right, I'll sign off. Thank you, guys.